All right. Great. Well, hello and welcome back to another edition of the Michigan Journal of International Law podcast. I'm Ryan Shaw, a current 3L and managing articles editor of the journal. I'm so excited today to be joined by Pearle Lipinski, who is the author of a fantastic article that is both legally and scientifically intensive, which we are excited to be publishing in volume 47, issue 1 of MJIL. Her article is titled Escape Probability: Rethinking Wartime Protection of Nuclear Facilities. Pearle Lipinski, welcome to the MJIL podcast.
Thanks so much for having me, Ryan.
Yeah, we're glad to have you. So first, just wanted to do a little bit of bio before we dive in, because I think Pearl has a really interesting and unique background. So she's a graduate of the Ohio State University, Moritz College of Law, and a current PhD candidate at OSU in the nuclear engineering program. She is actually the first dual degree candidate in that unique combination of topics in law and in nuclear engineering, and we'll overlook the OSU part of it all.
I appreciate. I overlooked the M when I was submitting my article around, so a mutual.
Wonderful.
Yeah.
Yeah. We'll just gloss over that. But Pearl is also an International Atomic Energy Agency Marie Curie Fellow, and she also has extensive experience advising the U.S. Navy and Air Force as a subject matter expert on aircraft testing, development, and sustainment. Most recently, she was a systems engineer for PE Systems, where she also advised the Air Force in a part-time capacity. And looking at your CV, I also found it interesting to learn that Pearl was an All-American captain of the air pistol team while studying aerospace engineering at MIT, which could well be the subject of another podcast. So suffice to say, as someone with kind of technical engineering background, you have really a non-traditional, kind of background and backstory for an attorney, for a legal scholar, for someone publishing in a law journal. So just kind of curious why you decided to attend law school, how that fits in with your engineering background, and how you think your engineering education has shaped your legal thinking.
Sure. So my reasons for going to law school are not great. So my husband is a military physician and pilot, and he was going to do residency at Ohio State. And as you mentioned at the time, I was working for the Department of Defense on life support systems for aircraft. So, like how pilots breathe in the aircraft and when they're pulling G forces, how the aircraft helps them out. And I was kind of tired of doing that. So I looked at graduate programs that were 3 years long, which was the length of his residency, and law school was 3 years long. So that is originally why I went to law school, was because it was the same amount of time as my husband's residency. But I found I really enjoyed it, and I think this why I enjoyed it ties into your question about how the engineering background influences legal thinking. So I think something that is missed by especially engineers is that as engineers, we have a design space within which we are constrained, right? So we have to have certain materials that do certain processes that result in a certain, say, temperature or pressure, and we still have to work within that design space. We're still constrained by physical things. And I think that actually translates pretty well to law, was what I found when I first started law school, where you can draw a parallel to you have a body of law, whether it's state, national, local, and this instance we'll say international, and you have a set of facts, and you have to work to kind of make those facts fit within that, we'll call it a legal design space, to get the outcome that you're looking for. If you're able to get the outcome that you're looking for, right, you can kind of fail to make your argument in law the same way you can fail to design something in engineering. So I found that really enjoyable, that the thinking I felt actually was a lot more cross-cutting and cross-applicable. And in my current work within the nuclear field, I have found it really useful and really enjoyable to also take what's a very highly technical field and a highly regulated field at the same time and be able to kind of speak both languages has been just a huge boon for me just to enjoy my work, right? Um, so anyone out there who's thinking about it, just take the plunge. There's a lot of writing in law school if you're an engineer out there, but I actually think that the skill sets translate pretty well.
Well, that's certainly good to hear. I don't think that they would translate well for me necessarily, but I'm sure there are others out there who could take inspiration from your encouragement. But I do think it's a super important kind of crossover set of skills for someone to have because we've seen kind of the regulation of uh, nuclear development, whether it comes to kind of the targeting of nuclear facilities in war, like you're discussing in this article, or just kind of increased global tensions around the topic. So I'm wondering if you could just kind of give us a top level, broad overview of how international law currently regulates nuclear technology, then maybe move into specifically how it regulates, protections around nuclear facilities. And I guess the third part of the question is if you could maybe just talk a little bit about what is international humanitarian law, and what are the Geneva Conventions, and how does that all tie together?
Okay, so I'll start with the first bit, and please get me back on path if I miss a question in there. I have a newborn at home. So the first bit about it's interesting that you phrased the question as international regulation of nuclear technologies because regulation within the context of international nuclear law is preserved exclusively for the national regulatory bodies. That is an express tenet where the ultimate responsibility for the regulation of these technologies is incumbent on the national state. So there is no, say, overarching regulation or regulatory structure, regulatory agency for managing the conduct of people, companies, or governments who are engaging in activities relating to nuclear materials. What there is instead, primarily managed by the International Atomic Energy Agency, which you alluded to earlier, is a suite of treaties, conventions, and soft law that broadly fall into four categories. They're called the 3S plus L paradigm, where you have safety, which really is about protecting people and the environment from the risks of nuclear material. The second S is security, which is about protecting nuclear material from people. It's kind of the inverse of safety. Safeguards, which is about ensuring that states meet their obligations to not proliferate nuclear weapons. And liability, which is even though we might have all these safeguards in place, procedures in place, mechanisms in place, at the end of the day, failure is inevitable. So, how do we make the public whole or any injured parties whole when a nuclear incident occurs? It can be transboundary, it can be large, it can have a large number of plaintiffs. So, the nuclear liability. Um, Within that, states can they can adhere to any of the various conventions and treaties that are part of that paradigm. And then when you ratify your country's acceptance of those treaties, then you are obligated to reflect the provisions of those treaties in your national framework. Um, Nuclear, in this sense, tends to thus be very reactive in the international sphere. You don't really see new instruments of law or amendments to instruments of law unless there's an incident. So I touch on two of these in my paper, which I'm sure the public is well familiar with, or the Chernobyl and Fukushima incidents are like seminal, events in nuclear safety. 9/11 is a seminal event in nuclear security. Nuclear liability had some other events in the 50s and 60s that resulted in its development. So, to answer your question, there is no, like I said, there's no international regulation. There's more of an international suite of law, is how we refer to it. Um,
Yeah.
so, yeah, go ahead.
No,
So,
perfect. I
hopefully I
guess
explained that okay. Yeah.
no, absolutely. And I guess just helping us kind of transition more into the topic of your article, like if you
Sure.
could just talk a little bit about what is a nuclear facility? I mean, like just at a very kind of base level for a lay person, like what is a nuclear facility? What are the risks that come along with their existence, especially once you get into potentially an armed conflict in which, targeting and as I, previously alluded to, international humanitarian law kind of comes into play. Could you just talk a little bit about the what facilities are?
Sure. I'll keep this brief because if you want a broader, more detailed overview of how accidents happen, you can read my article. So very broadly, a civilian nuclear facility takes the energy that's contained within the atom, splits the atom, and releases energy that's then converted into heat, which is converted into electricity. The fundamental concern and risk associated with that is the release of radiation. So, as I describe in more detail in my article, radiation, when it interacts with the body, can be energetic enough to actually cause direct damage, or it can be less energetic and interact less with the body and alter DNA and cause cancer and other diseases down the line. So that's kind of the fundamental risk, and the nature of that risk is kind of inherently especially a nuclear facility, transboundary, which is one of the reasons why international nuclear law has evolved as a very particular field. And within the context of international humanitarian law, why it's gotten a specific carve out in the Geneva Conventions. So, backing up a little bit to your question about the context of international humanitarian law, it's what popularly is described as the law of war. The softer way to then describe it is the law of armed conflict. And I think if you ask the Red Cross, their definition is the law that seeks to impose limits on the destruction and suffering caused by armed conflict. So you can kind of
Right.
see how we get a little bit less alarming as we, yeah.
And just to clarify, this isn't kind of a legal framework that says when it's right to start a war or to go
No,
to war.
yeah.
This is the framework that says we're assuming that an armed conflict exists. How can actions be regulated? Assuming that existence already.
Correct. And that goes into where the Geneva Conventions fit into this. So international humanitarian law kind of has two broad, uh, we'll say, areas of conventions. So one of them is about kind of prohibiting and regulating the type of weapons that can be used in war. So that's where you get prohibitions on biological weapons, on certain chemical weapons. And then the second part of that is sort of, like you say, given that war has happened, how do we protect non-combatants and those who are no longer engaged in the conflict? And non-combatants doesn't necessarily mean civilians. That can be anyone who's wounded, a combatant who previously was fighting, who was wounded, sick. They're shipwrecked is one of the original Geneva Conventions. It's about protecting shipwrecked combatants, prisoners of war, and civilians. So that's where the Geneva Conventions come in. There's what we call the Geneva Conventions is actually six instruments. So there were four original ones that were really focused on when combatants became non-combatants, like I mentioned, prisoners of war, shipwrecked, wounded, sick, and civilians. And then the additional protocols one and two, which kind of broadly called all of those groups of people victims. So protection of victims in times of armed conflict, where it also clarified a few things, codified a few things in the original Geneva Conventions, and added a few other provisions, which is where nuclear facilities come into play. As well as, I think this is worth noting, additional protocol 2 applies to armed conflict that is between like a state body and a non-state body within its own borders. So, which wasn't really well captured in the initial kind of the history of the context of what was going on in the original Geneva Conventions after these sort of broad global conflicts. There was a need identified to capture conflicts between state and other groups inside its own borders.
And your article focuses on a specific provision of additional protocol one. Is that correct? Is it
Correct. Yep.
also okay? And that, as you mentioned, relates to the protection of victims of international armed conflict. So this is Article 56, which talks about the protection of nuclear facilities during an armed conflict. So what does Article 56 say? And in your view and in your argument, where does it fall short?
Sure. So Article 56 is about attacking facilities containing quote unquote dangerous forces. So the three that are enumerated, and this was very deliberate, if you go back and go through the commentary at the time, are attacks against dams, dikes, and nuclear electrical generating facilities. and you are prohibited from attacking these facilities if such an attack may cause the release of dangerous forces and consequent severe losses among the civilian population. So there's a few carve-outs where such an attack would be permissible. The most notable one is if these facilities are providing direct support to military operations. Also, if you were to, say, attack your own facility to prevent the enemy from advancing, that is technically permissible under under a close reading, where attack is only against an adversary. So let's say dams are a classic example. If you were to burst a dam to prevent the enemy from progressing, that would be permissible for you if it was your own dam as opposed to the enemy combatant attacking the dam. And where I think it falls short is fundamentally in the like what I just mentioned, the pure definitions of it. Um, I which I kind of well, I think we'll address maybe more in the podcast is to actually have consequential severe losses among the civilian population from a nuclear accident historically has simply not happened, which is the general thrust of my article. When you take a look at the most significant radiological events that have happened across the current operational history of nuclear power, you can really only directly attribute at a maximum around 30 deaths to radiation exposure from Chernobyl, which I think you, me, the rest of the world could acknowledge that's, the worst nuclear accident in history and hopefully will be the worst one. But when you start to get into, well, is every instance of cancer, is that a consequent loss to the civilian population? Is that on the right time scale when you're looking at 30 years later? And I'm just not sure that the current language of Article 56 really captures what should be a huge disincentive to commit an act that we kind of as a global society feel is totally inappropriate. But since historically, again, nuclear accidents don't cause a lot of direct fatalities, I'm just simply not convinced the language captures the intent, which is to deter attacking those facilities outright.
Yeah, no, absolutely. But I think in the last, I guess, 4 years really since the invasion of Ukraine in February of 22, coming up on 4 years since that occurred, the urgency for this kind of discussion has increased, and we've also seen, in the last year, tensions between the U.S. and Iran, Israel and Iran, potentially putting this, back in the spotlight where it hadn't been before kind of the 2020s. So, could you talk a little bit about just how recent events, maybe you focus on Ukraine quite a bit in the article, how this has kind of raised the level of urgency for updating the language and how a kind of framed or redrafted version of Article 56 could better address some of the threats that we see coming out of something like the Russia-Ukraine conflict.
Right. So it is interesting, and others have written about this too. I make some cites to some of their other work in my article where this is not the first attack on a nuclear facility. So I do want to kind of back that up a little bit. Where in the 80s there were attacks both on research reactors in the Middle East mostly and on a nuclear power plant in Iran, which interestingly there was some global condemnation for the attack itself, but the world kind of accepted that the radiation release risk was low, which I think is a strange contrast to the response to the attacks in Ukraine. I'm not sure why that's the case. I think perhaps we kind of started to believe that nuclear power plants were in fact the sort of sacrosanct thing, right? Like, oh, of course no one would attack them. We don't want another Chernobyl. And then of course and then we look at a plant that's now under occupation, which is in fact Chernobyl, right? Um, I personally think that the attention that in the past 4 years, that this issue has gotten is not actually capturing the true need for urgently reviewing this, which is the future deployment models for nuclear reactors. So right now, nuclear reactors are having a huge moment, right? Everyone's talking about how they're going to help us get to energy security. Others are more concerned with climate change. Regardless, of your reasoning for being a proponent, it seems like nuclear power is having renewed interest. And a big part of that is what are called small modular reactors, where they're still large. They fit on like the flatbed of a truck, we'll say. They're not, going in your home office. But they're meant to be more deployable, they're meant to be more versatile, they're meant to be smaller, and there's a subset of those that are truly micro. So they are meant to be, there's a concept for nuclear batteries, there's concepts that have you deploying, we'll say 10 megawatt reactors out in the middle of the Arctic and military bases. And I personally think that is what brings about the greater urgency here, where if we're not capturing attacks against large facilities, which is right now the status quo for nuclear power, we definitely aren't capturing, I think, what we're looking at a broad deployment of many, many more reactors, hopefully by in the next 20, 30, 50 years. And when you kind of going back to the language problems where only nuclear electrical generating facilities are covered. So let's say we have a core for an SMR, a small modular reactor on a flatbed, kind of just transiting around, and it gets targeted because it's unintentionally, say, in a convoy or it's mistaken for something, and that causes a release of radiation. Like that scenario is simply not covered. It's not generating electricity, it's not an electrical station, it's simply a component. And I think that those parts of the nuclear, we'll say, operational life cycle are really going to start to be a lot more common. And that's where I believe that the language simply needs to be updated. And I think at the time I can only speculate, right? I'm 35. I can only speculate what was happening in 1977. But I think at the time that the additional protocols were written, that sort of deployment was kind of limited really to military use. So submarines technically have like small reactors, but I just don't think it was envisioned that a reactor would be anything other than this sort of giant static behemoth, facility. And that wasn't accounted for.
We might anticipate that these reactors, which we think of Chernobyl as being like what a nuclear facility is, but what you're saying is that we're going to start seeing potentially a proliferation of much more compact, you could call them facility, you could call them reactors, uh, that are just going to be much more common across the globe as we see
So
it take.
that's the dream, right? I don't, I
Yeah,
don't, I don't know if that's going to happen, but that is currently what people are pushing for with nuclear, right?
right.
And again, like how do you capture that? And that doesn't even address what others have also noted before. So I cite Vonda Lam's article. If you're interested in another good article on this from the 90s, about kind of gaps in Article 56, and her primary identified gap, which again has only grown, is that there's a whole slew of other nuclear or uses for nuclear and radioactive material that aren't captured. So research reactors, which I think Michigan has one, Ohio State definitely has one, are not covered. Any sort of nuclear like enrichment facility that isn't generating power isn't covered. Any sort of spent fuel facility, which can have highly radioactive byproducts, isn't covered. This gap has existed for a long time. And again, I just believe the urgency of it is now because we're looking at a type of deployment that simply wasn't anticipated at the time.
Yeah, yeah. Now, we talked a lot about additional protocol one, and that's the kind of central focus of your article, and updating that to kind of fill in the gaps. Are there other international legal mechanisms that exist to kind of regulate state responsibility for attacks on nuclear facilities? Uh, is it possible that these can work in tandem with the Geneva Conventions, or is it really just that lone provision?
Yeah, so kind of going back to the beginning where I mentioned that 3S plus L paradigm. Under international nuclear security law, there are a handful of conventions and treaties which one might initially think create obligations to the state. Um, the two that I think are the most relevant would be what's called the Convention on the Physical Protection of Nuclear Material, which provides that states must implement certain mechanisms to prevent like theft or sabotage of a nuclear facility, and the International Convention on the Suppression of Acts of Nuclear Terrorism, which covers prevent, like, again, states have obligations to criminalize certain acts related to the use of nuclear materials for terrorism, as well as reaching back into the physical protection. Both of those conventions. Although you might say, well, like, hey, that raises interesting questions about, especially if a power plant's under control of an adversary, maybe the responsibilities change, and that might cover armed conflict. Expressly say they do not apply in the case of state-managed armed conflict. So, with respect to nuclear terrorism, only applies to individuals. With respect to physical protection, only applies outside the context of an armed conflict. So, they actually are expressly removed from being relevant during times of armed conflict. And so that does just leave the Geneva Conventions as the sole sort of international law mechanism to say, hey, we kind of, as a global society, I to use that term, but we've kind of made the decision that attacking nuclear facilities is not something we want to allow or endorse. And I think then at the end of the day, that provision should be strong enough to actually capture what attacks we feel are inappropriate.
Well, I think your article is just a really, even if kind of nuclear regulation isn't someone's kind of, specialty or topic of, the topic that they're most interested in international law, it is a really good kind of critical analysis of the ways in which kind of international conventions might be inadequate in 2025 and beyond. So I guess I'm kind of wondering to round out the substantive questions on your article, if there's broader lessons that the international legal community can take from your analysis of Article 56, in that your argument seems to be that Article 56 is too specific. It's seeking to regulate kind of kind of specifically enumerated events rather than maybe the negative effects that we're trying to prevent. So I guess are there lessons to be taken for how drafters or negotiators of international treaties or conventions in the future can kind of learn from the inadequacy of Article 56, even if it doesn't have to do with the regulation of nuclear facilities?
Yeah, I mean, I guess I can think of two things that I would hope some might take away when reading my article, which is that I think that there should be kind of a focus on consequence, which I think is a little bit missing, is one of the kind of the key thing missing from Article 56, right? Like at the end of the day, attacking a nuclear facility is bad. But what we want to prevent is the release of radiation. And so it's like, okay, well, what release of radiation do we want to prevent? And if the answer to that is any release of radiation at all, then we don't need to qualify it anymore, which is part of the problem of the way it's currently written, where it says consequent release and subsequent severe civilian losses, right? So if it's just the release itself, that's the act we don't want. I think we talk about how, like you mentioned, how I say it's too specific, and I think that's accurate, where there was really no reason, or I see no reason to kind of extend the what you need to prove to say that the act is a war crime, when the initial consequence is what we want to prevent in the first place. I think the second part of it is at the time, Article 56 was like really lauded for including nuclear facilities, and it wasn't seen as overly specific. It was seen as kind of forward-looking. And I don't really know if this is possible across all facets of international humanitarian law, but I think the current sentiment that now Article 56 is inadequate is not necessarily one that's new. Like I mentioned a couple articles that existed prior that identified other gaps in Article 56, but could have been readily addressed earlier if it had ever been reviewed, right? Like I think sort of some of the deployment scenarios now, like I said, create a certain urgency, but a lot of the gaps are fundamentally things where for example, the accidents that I analyzed in my article and try to apply to Article 56 are the most recent one's 2011, right? Chernobyl happened in 1986. At the time of Article 56's writing in 1977, there had not been a major nuclear power accident that was known. Three Mile Island was in 1979, and again, Chernobyl was in 1986. And nonetheless, there wasn't really any sense or need to kind of review the provision in light of the consequences of those accidents, which might not have been obvious at the time. It might not have been perceived as needed. Obviously, resources for these sort of things are stretched extremely thin. But I do think that I would hope that, especially for other highly technical systems, maybe this might get people thinking about doing a review and kind of reassessing how technologies have evolved and therefore how the laws that are looking to we'll say regulate, we'll use that term very loosely, not as the term of art, but as laws, how laws regulate that technology could also look to evolve and catch up before we actually have a problem.
Great. Well, I think it's a really timely, kind of deeply researched and technically sound article. And so, really hoping that any listener of this podcast goes and takes a look
I appreciate it.
at Pearl's article after this. But I wanted to just move into two kind of wrap up fun questions that we'll do for all of our authors here. The first one being, if you could recommend one piece of media on international law, it could be a book, it could be an article, or it could even be a podcast or a movie. Do you have a recommendation?
I'm going to stick within my very niche field of international law, which is international nuclear law. So the Nuclear Energy Agency, if this is a field that you have like any interest in at all, has published a really fabulous compendium. It's called Principles and Practice of International Nuclear Law. It's like free PDF online. And it's stylized with a long series of articles that go over kind of the structure of international nuclear law and the four areas that I talked about and kind of how they've evolved and developed. And I think what's really cool about the compendium is a lot of the people who wrote the conventions wrote the articles, right? Like it's a kind of a very small area of scholarship. And so you end up with a lot of really good insights, I think, in a way that sometimes you don't get out of a lot of legal academia from the people who like wrote the treaties and wrote the conventions and went to the, review meetings. So if you have any interest in international nuclear law, that would be my take. It's a little dense, but I think as like somebody's interested in legal scholarship yourself, I think you'd find it interesting.
Yeah, absolutely. That's a great one. I would add on the complete opposite end of the spectrum. I did enjoy the HBO show Chernobyl a few years ago. So both of those are probably good places to go from here.
Yeah, I would
Uh,
also say, I will say, if we're looking at Chernobyl technical things, the original IAEA report on Chernobyl is also kind of an interesting read. It's called INSAG 1, and INSAG is International Nuclear Safety Advisory Group dash 1. And it was like the first like major review this group ever did on a nuclear incident on behalf of the International Atomic Energy Agency. So it's just kind of interesting from a Chernobyl being the seminal event in much of nuclear law, kind of seeing how where those roots sort of came from with respect to safety culture and how we started to look at developing standards for reactor design and that sort of stuff. So sorry, a more technical take than HBO's Chernobyl, perhaps.
no, no. I that's why you have you on and not just me recommending the HBO shows. So, final question. What would be your advice for a law student who wants to publish a sharp original work of legal scholarship?
So I would say two points, and some of these come from one of the best pieces of advice I'm stealing from a professor in law school. So my first piece is do something that you care a lot about, and this is from my perspective. So I care a lot about nuclear energy. I have a couple pieces in work relating to like aerospace law, and it's something that's interesting to me and that I feel not you don't necessarily have to feel knowledgeable about it, but kind of feel passionate about it. I think sometimes when you guys are looking at writing your notes, there's this kind of excitement where you're like, I could do, this amazing piece on like a Supreme Court case or something, or like, we're not all going to be, we can't all make Amazon's antitrust paradox as students, right? Like,
We're not
you
all
know,
Lena Khan, yeah.
yeah, like we can't all do that. And I think it's like it's easy to fall into the trap of being like, well, maybe that's me. And maybe it is you. I'm not saying that's not you. But more than choosing something that you think is of interest to other people, first and foremost, make it of interest to you. You're not going to be able to write something sharp and interesting if you don't care about the content. How are others going to care? And then the second piece, I'll keep this short, was again from a mentor in law school, and she said, always remember that you're writing a slice. You're writing about a slice of the law. You can't write about all of international nuclear law in a single article. You can't write about all of international humanitarian law as it applies to nuclear in a single article. My slice for this article was looking at it from the perspective of severe accidents and the consequences of accidents as they might be applied to a theoretical attack. And that's pretty precise. And there's still a ton to write about, and there's still more I could have written about in the context of that. But unless you kind of keep your piece focused, you're not really going to be able to write anything that, as you say, is sharp and original.
Well, Pearl Lipinski, thank you so much for joining the MJIL podcast. Really enjoyed discussing
Yeah,
your
thanks,
article with
Ryan.
you
Thanks for
today.
having me. This is fun.
Absolutely. All right.